I think that there's a characterization issue here, and you got a bunch of rules that sort of coincide. There's first of all, there's an issue of whether or not he is in fact a partner, because if he is a partner, then that's I mean, notwithstanding what his internal relationship may be with the other members of the firm, he may be a partner to the outside world, in which case he's a partner for GST purposes, and his liability can be taken through the GST return. Secondly, there's an agency rule that essentially is there to deal with undisclosed principals. I think it's around Section 177. And if in effect all of his services are being billed to the public under the name of a particular law firm, even though he may have a separate relationship vis-a-vis that law firm, his revenue side may effectively be governed by this agency rule, which would contemplate that the partnership as the agent, I guess, for this person would effectively bill and collect the GST on his behalf. Now that doesn't, however, answer the question of his liability to issue invoices and to collect GST for the services that he renders to the partnership. So there may still be an issue in there, and I think that I guess all I can say is that it involves an issue of characterization, and you have to break down what is his relationship to the firm. But I think that the pure answer is the one that Irene gave, is that if you conclude he's not an employee and he's not a partner and he's performing services for a fee, if he gets more than $30,000 a year, he has to register and he has to collect GST on the fees, in effect, that he's charging to that 20-man partnership.
You don't have to issue an invoice to be considered rendering a fee. You know, lots of people get automatic royalties, authors, it's all over the map. And I think Revenue Canada would look for a return from that lawyer.
So the possibilities are convert him into a fixed interest partner, either fit him into a slot and make him a fixed interest partner, or give him a status that clearly makes him a partner, or make him an employee. And now, however, having said that, Revenue would look to how he's classified for income tax purposes in characterizing him for GST purposes.
But it's a wash. I mean, it's a wash. I certainly wouldn't spend a lot of time trying to make him not fit within the rules, because he just has to file a return, remit the tax, and you claim it as a credit.
But he would have books and records. And
a few books and records.
Hey.
You were going to say what he does for income tax purposes?
So assuming that I'm saying for income tax purposes, it may make no difference whether he files some type of independent consultant contractor receiving $100,000 as consulting fees, or receiving $100,000 as partnership draw or shared partnership income. I would think not that would make any difference for GST purposes as to that liability. It may make a difference for GST purposes.
Yeah, it seems to me that person is very much akin to a counsel, even though he's not a counsel per se, and that consequently he should register. I mean, it's clear that the billings are the firm billings. I mean, that's how counsel work in our firm. The work they do goes out on our firm accounts, etc. And it's described very similarly to what you've just described, except that you don't call them counsel.
That's a good question. Well, that brings us to the end of today's proceedings. It's been a pleasure being here. Thank you very much for your attention.
I think that, is that you?
That's me. That's me.
Okay. Let's go.
That's a deadly question. I tried to do that.
I know.